Learn from an attorney when bullying is considered severe and pervasive enough in the eyes of the law for a lawsuit to maybe be successful against a public school district. Kids, get your parents. They need to see this. Hi, I'm Stacey Storino, an attorney since 1998, certified life coach since 2015, and the leader in legal coaching that turns people into effective advocates for themselves and their loved ones when they're bullied, special needs, or both. Woman 101 stands for wisdom that turns victims into victors. Now, let's get down to when bullying is considered severe and pervasive enough by the law for a lawsuit to maybe be successful against a public school district. Stay tuned until the end of the video so that you can learn about a method to stop bullies after all else fails. Yup, there is a method. As discussed in a previous video, the standard across the United States, which is still good law today, that dictates a school's obligations when it comes to student-on-student harassment, was laid out in a case called Morse versus Lower Merion School District in 1997, which says, quote, "The general rule is that the state has no affirmative obligation to protect its citizens from violent acts of private individuals," unquote. Now, if that sounds crazy to you, and I get that, check out a previous video that I made that goes over this standard and a case that helps carve out ways in which you can possibly hold a public school district liable anyway. That case came out in 1999 and is called Davis versus Monroe County Board of Education. And it set up what's now referred to in the courts as the Davis test or the Davis standard. The Davis test holds that state funding recipients, like a public school district, can be held liable in damages only when they are deliberately indifferent to student-on-student harassment, of which they have actual knowledge. That is so severe and pervasive and objectively offensive that it can be said to deprive the victims of access to the educational opportunities or benefits provided by the school. Today's video handles one prong of the Davis test, and you can take notes to see if you have the facts and circumstances and evidence to support it, that you can maybe get that public school district's attention if it's been ignoring you, and maybe even sue it and win. Today we look at what's considered quote-unquote severe and pervasive enough in the eyes of the courts to help satisfy one of the multiple prongs of the Davis test. All of the prongs have to be satisfied, remember, but we'll take them one at a time in this series. Okay, ready? One incident can in fact be severe and pervasive enough so that that prong of the Davis test is met, but you have to have the right set of circumstances for this to be true. Enter the case of TZXREL-CG versus City of New York. The bullying victim in this case was a special needs student under 14 years of age who had been sexually assaulted by two fellow students in a classroom while a teacher was present. The teacher was apparently working on a computer when the victim was groped by one boy who held her down while another boy removed her clothing and touched her buttocks, while other students watched. After the incident, the victim was crying in her friend's lap, and that's apparently when the teacher stopped working on the computer and told the victim to return to her seat, while the students who sexually assaulted the victim were suspended for 87 days. As you might imagine, the victim was a mess. She suffered from worsening grades, the need to enter into psychotherapy. She was diagnosed with post-traumatic stress disorder and engaged in self-cutting, suffered severe nightmares, had difficulty sleeping, flashbacks, panic attacks, uncontrollable crying, loss of concentration, loss of energy, impulsive aggression against boys, and difficulty sleeping. Ultimately, she was put at a high risk of suicide, and her therapist indicated that all of these symptoms and issues came into existence following the victim's assault at school. Now, the United States District Court, Eastern District of New York, noted that this was a case where Title IX was in play, meaning Title IX of the Education Amendments of 1972, which provides that, quote, no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance, unquote. Like public school districts. So, citing Davis versus Monroe, the court in the TZXRLCG case recognized that a plaintiff seeking recovery for a violation of Title IX based upon student-on-student harassment must prove that the alleged harassment took place in a location within the control of a federal recipient of federal funds, again in this case a public school district. The court cited the Davis test by acknowledging that first, an appropriate person must have actual knowledge of the alleged discrimination or harassment. So you understand, quote, an appropriate person, unquote, is at minimum an official of the recipient entity, public school district, with authority to take corrective action to end the discrimination, a concept that was discussed before the TZXRLCG case in a different case called Gebser versus Lago Vista Independent School District. So in the case of TZXRLCG, the teacher who was in the classroom working on his computer while the sexual harassment of the special needs student occurred was, in fact, an appropriate person who had the authority to try to take corrective action to end the discrimination. The court went on to acknowledge a funding recipient, like a public school district, was liable for peer-on-peer harassment only if, quote, the funding recipient acts with deliberate indifference to known acts of harassment in its programs or activities, unquote. So, in the case of TZXRLCG, the teacher who was in the classroom working on his computer while the sexual harassment of the special needs student occurred was, in fact, an, quote, appropriate person, unquote, who had the authority to take corrective action to end the discrimination. The court went on to acknowledge a funding recipient, like a public school district, was liable for peer-on-peer harassment only if the funding recipient acts with deliberate indifference to known acts of harassment in its programs or activities. Also, the discrimination must be so severe, pervasive, and objectively offensive that it effectively bars the victim's access to an educational opportunity or benefit. Of course, the court said that if the teacher in this set of circumstances knew that the assault was taking place and did nothing, well, that could constitute deliberate indifference. But was a one-time sexual assault enough to give rise to being pervasive enough to satisfy a prong of the Davis test? The Davis case itself acknowledged that whether gender-oriented conduct rises to the level of objectionable harassment depends on many circumstances, expectations, and relationships, the age of the victim, and the number of individuals involved. Another case by the name of Hayut versus State University of New York acknowledged that physically threatening or humiliating conduct is more likely than offensive utterances to rise to the necessary level of discrimination to trigger school liability. But to have an actionable claim against a school, you have to show that the harassment had a systemic or global effect on a plaintiff's access to educational programs. And the hostile environment arising after a victim's sexual assault counts as having such a systemic or global effect on the victim, so as to, in essence, bar them from access to educational programs. Now, the TZXRL-CG court recognized that there had been other cases to hold that a single instance of assault was enough to be sufficiently severe to satisfy one of the prongs of the Davis test. For example, take the case of Doe versus Dallas Independent School District, where the court held that a single instance of assault in which a student inserted his hand into a victim's vagina, causing damage, was sufficient to state a Title IX claim. The Doe court reasoned that a serious sexual assault could affect a student deeply enough to bar her access to educational resources in a way that a simple offensive touching would not. In the case of M versus Stanford Board of Education, the court found that a single instance of rape that took place in the school's basement was exactly the type of action covered by Title IX. Back to TZ versus XLCG. That court, given the holdings of Doe versus Dallas Independent School District and M versus Stanford Board of Education, decided that a single instance of harassment, like sexual assault, even when it fell short of rape, could have the effect of denying a student access to educational benefits and opportunities, and therefore could satisfy the severe and pervasive requirement of the Davis test or standard. Does this mean that if you or your loved one wasn't raped or sexually assaulted, that the bullying abuse suffered doesn't rise to the level of being severe and pervasive enough to satisfy a prong of the Davis test? Not necessarily, but the bar is high. But there's also more than one way to skin a cat. The bullies themselves don't necessarily win the day. You can always get them individually, either directly or via their parents or guardians. Now, you as a layperson might be feeling a little overwhelmed, but no worries. We're going to break down all the prongs of the Davis test in other videos so that you can see how you can make it work for you or your loved ones. Because if you don't have your act together before you sit down with a school official about the subject of you or a loved one being bullied, well, they could blow you off or double talk you. And I don't want that to happen, and neither do you. So subscribe to this channel and be sure to keep coming back for more videos that will be put in the Enemy Remedy playlist. By the time you're done watching those episodes, you'll get the picture. Knowledge really is power. Gaining a support system that exists both on the school campus and off of it can keep a bullied kid safer. And when all else fails, it's time to call in the cavalry, meaning having at least one adult who can serve as your advocate with the school system and, if need be, the police and the court system. You can't ignore bullying. It won't go away. Every study and survey shows that avoidance has no upside when it comes to bullying. And I've got a system called the Enemy Remedy that can help you or the ones who love you out big time. So make sure you check out the link down below in this video show notes for more details. I would love to hear from you. Have you ever had a disappointing encounter with a school official over an incident that was severe and yet they didn't care? Share down below and let's have all of the Woman 101 Wise Owls love up on you and give you support. And if you like this content, please remember to support me on Patreon so I can keep providing new materials on a regular basis to help victims of bullying everywhere. Remember, Woman 101 stands for wisdom, turning victims into victors. Be sure to subscribe to this channel and like this video and share this with anyone you know who could use some support. Woman 101, be wise with your heart.